What is it?
Your Honor, it
What is
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire
phone number one of the comments.
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally asked
at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there and I asked for everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse here. It is what it is. I think that the state was disingenuous about it. State's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now. So I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that. But this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back.
She is on her way. There was, I think, some problems with traffic.
Okay, so, I mean, Ms. Hilton, Sunday, September 29th, 1:39 PM. Good afternoon. I hope all is well. Attached, you will find the media list for this week.
Then, Your Honor, I take full responsibility for that. I can address it. If it was sent, then that is on me, if it was sent out on Sunday.
Okay, well, anyway, luckily, the only person highlighted is somebody who's already been testifying, so it's not an issue for this time, but let's not have that happen anymore. Second, we do have a witness on the stand that we broke to handle Mr. Zachary for, so we need to be continuing with that witness and go ahead and finish up with that. In addition, you have even more last minute provided
Okay, do you see that's the first mistake?
an updated transcript at what, 8:30 or 10 or something o'clock last night?
I don't have to use that. I can.
Okay, that's good because nobody's had a chance to be able to look at it or compare it or anything like that. So, okay. All right, so can we get Mr. Sprinkle over to finish up his testimony?
Your Honor, Mr. Sprinkle, so as I explained before, I called Mr. Sprinkle when we intended to call Mr. Zachary. Mr. Sprinkle's testimony, and in order to avoid him being called twice, we were putting in the interview of Mr. Zachary, given his continued pronouncements regarding his health concerns and other considerations. We were going to call Detective Gaither to simply get in the interview regarding Mr. Zachary. Mr. Sprinkle's investigation, if you will deal with some of the information that comes from Mr. Zachary's interview. And rather than asking the court to call Mr. Sprinkle twice.
Well, we're calling lots of witnesses twice, or you were calling lots of witnesses twice, so.
Your Honor, I'd ask the court's permission, since we do have Detective Gaither here, to allow us to put in Mr. Zachary's interview and to allow us to proceed after Detective Gaither with.
And what, is Detective Gaither just going to be introducing the interviews?
She's going to be introducing the interviews. Primarily, that is the reason that we have her. She also confirmed, though Mr. Zachary was able to confirm some information about his phone number, another phone number. I told her that I don't expect to keep her very long. I don't expect her to be more than today, frankly. And yeah, that's it. And the other matter that I wanted to broach with the court simply dealt with the concerns that the court had that we broached briefly regarding some of the cross-examination testimony and some of the information in the interview with Mr. Zachary on the 5th of August, 2015, that we believe has addressed some of the concerns that the court had regarding.
I'm sorry, but I don't know what you're talking about.
So in my email to the court, I said that there were some matters that we would ask permission to address prior to playing the interview. Some of the portions of the interview that defense requested redacted, the court said that it needed sometimes foundational information before I went ahead and.
Okay, and I think that Ms. Persfield responded to everybody that we're not going to address that this morning before, and we know that the jury is going to be here and ready to go at 9, and I don't think there's going to be time to address all of that in the 5 minutes before the jury is here. Do you?
Well, there's one that I think we can. It's the first one that we have listed.
Okay, well, anyway, that is what I said we would address either at lunch or at the end of the day, correct? All right, and so for that reason as well, we're not really ready for Detective Gaither's testimony. So go ahead and call Mr. Sprinkle over and let's pick up with him, because we can't, if we need to do the whatever is or is not going to come in the interviews, and it's different from what we had already made determination about, and we left some things for determination. We have to figure that out during the lunch break. So
Yes, Your Honor. Will
All
the
right.
court permit me to step out and make that phone call?
yes, please.
And also, Your Honor, so will the court be permitting me or allow me to bring Mr. Sprinkle back after we get in the
I mean,
testimony?
it seems to me like that's been kind of the way this case has gone. It's that people get called back 2 and 3 times. So sure, you can do that with him too.
Excuse me, babe.
We got about 5 minutes.
Okay.
You know, hey, hey,
of returns, I'd just like to briefly address something.
Okay.
Thank you.
I'm just getting off. Set it down.
All right, Mr. Weinstein, you wanted to address something?
Yeah, just briefly, Your Honor, and I'm not sure when the state plans on using this, but on the 27th of September, so what, 3 days ago, we got a Dropbox link with additional crime scene photos from a 2019 case, a 2014 case, and a 2015 case. These hadn't previously been provided.
Of what?
Well, I think you'd have to ask maybe Mr. Atkins or the state. One of them relates to, I just have APD case numbers. I think they could give you more detail.
Okay.
My main point being these should have been provided in December of 22 at the latest. So I don't know why we're just receiving these now. And it seems to be my role in the case. I'm here to once again complain about late discovery, Your Honor.
Ms. Love?
Your Honor, I'd ask the court, since that is not something that will be broached this week at all, that the court allow us to address the matter when I have those files in front of me that Mr. Weinstein.
How about you get
referring
those
to.
files at lunch? Seems to me like
We
we're
can
going to
do
have a
that.
lot to talk about over lunch.
We can do that, Your Honor. And also, I will say that those are, to the extent that, of course, I will look back and make sure that they were not previously provided, but to the extent that they were not, the crime scene information that we have turned over is a direct result of matters and witnesses that we have added back because of the objections that have been made. And the CAD reports, I believe, have already been admitted as evidence. So there is nothing about the photographs that would create any delay or prejudice or anything of that matter, but I'll address it at lunch.
What were the dates?
These are cases from, according to what Mr. Atkins sent, 2019, 2014, and 2015, Your Honor. And Mr. Atkins, in an email to me on that same date, the 27th, indicated to me that these had not previously been provided to us. So we can discuss it at lunch as the court wishes, Your Honor.
Okay.
If you
All right. Ms. Love, in your Sunday 6 p.m. email, you said that you were going to forward later in the evening to counsel and the court the portions of Mr. Zachary's interview that you were seeking reconsideration of based or because of, I guess, the way he testified. I'm not in receipt of that forward. Did you ever forward what the actual portions are?
Your Honor, I think, no, I forwarded the transcript, the corrected transcript that I was seeking.
But you
to-
didn't forward the portions that you had that either I had ruled out or you had agreed would be out?
I did not forward those. There were,
And yet that's what you expected everybody to argue this morning without even knowing what those were. Could you please forward those at your earliest convenience so that we will know by lunchtime what it is that we're talking about?
absolutely.
Excuse me. And I didn't receive the transcript last night.
Well, she's agreed that she's not going to be using the transcript because nobody's had a chance to look at it. So
Thank you,
you don't need to worry about that.
Thank you, Your Honor.
But I don't know if somebody's going to be over here to assist you later in the morning, but as soon as somebody gets here, you need to get that taken care of, okay?
Yes, Your Honor.
All right, so is Mr. Sprinkle out there ready?
He said that he needed 10 minutes from the time that I reached him. So
Tell him, text him now and tell him he needs to get over here right now.
he is, Your Honor. He is coming. He
Text him
literally,
anyway and say the 10 minutes, he can't have any more time. He needs to stop what he's doing right now and come on. Because we have the jury waiting.
yes, Your Honor.
And then while we wait, I guess you can go ahead and forward us those portions of the interview that you think need reconsideration, since we'll just be sitting here doing nothing otherwise.
Yes, Your Honor.
Thank you.
Jury right here too.
Oh, look, there's Mr. Sprinkle. No, you may not. Let's get the jury in. Mr. Sprinkle on the stand.
Yes, Your Honor. Thank you.
All right, for jury. How's your first one?
Thank you. Good morning, ladies and gentlemen. I hope that you enjoyed your unexpected 4-day weekend. I hope that nobody is too badly impacted by the storm that swept through. And we are ready to proceed. And we're picking up with Mr. Sprinkle, who was on the stand, I don't know, early last week maybe. But anyway, go ahead, Ms. Love.
Thank you, Your Honor. And good morning, DDA Sprinkle. How are you?
Very well. How are you?
I'm good, thank you. So when we last left off, you were explaining to the jury regarding the investigation into the murder of Donovan Thomas, the additional steps that you took in determining what to do with the file once you received it from the Atlanta Police Department.
Right.
All right. And you had explained that there were jail calls that you were able to listen to make certain determinations regarding information that was a part of the file.
Can y'all hear her okay? Everybody can hear her? Okay. Where'd your lapel mic go?
Would you rather, okay, even at the podium?
I don't know. It just seems, if everybody can hear her, that's fine. It just didn't seem as loud. Go ahead.
I can grab it.
Maybe while he's answering, you can hook it up.
I don't think I can do both of those. This is a difficult contraption. I'll talk into the microphone.
Okay.
All right. So, Mr. Sprinkle, with respect to Spencer Wright, or the person that Detective Thorpe spoke to before taking out the warrants and the jail call that you listened to,
Correct.
is my memory correct that you said that Detective Investigator David White was the person who then spoke with or went out and reached out to the person that Mr. Wright called from the Atlanta City Jail?
That is correct.
And the information that you received or that you were able to gain from that phone call made from the Atlanta City Jail, what impact did it have on your investigation into the murder of Donovan Thomas?
It corroborated what I already believed, which was that Spencer Wright, who initially provided the name of Nicholas Rob.
I'm going to object to that testimony. As to relevance, his belief is not relevant.
Sustained.
So as a result of the information that you got from that phone call, with respect to information that would assist you further in the investigation, what did you do after you listened to the phone call and had Detective White speak to Mr. Smalls?
Well, I spoke with Detective White. Well, broadly, I just embarked on the investigation of the murder of Donovan Thomas because at that point I was essentially I was certainly without sufficient evidence.
Okay.
I can no longer rely on that statement.
All right. Now, at the time that you got the file, had Kenneth Copeland already been interviewed?
He had been.
All right. And when you reviewed that, those interviews of Kenneth Copeland, did you endeavor to speak with him anymore, or did you gain more information from the interviews themselves that assisted you in your investigation?
Well, as the investigation, as the months went by, I did desire to speak with Kenneth Copeland, but that did not happen. He wasn't willing to speak with me.
How many of his interviews did you have at your disposal?
Well, I believe there were 3. There was one in particular from June of 2015.
That the 9-hour interview?
That would be the 9-hour one,
All
yes.
right. Did you set out to corroborate anything that you
Objection,
found?
Mr. Dean.
I'm sorry.
Sustained.
Yeah, I didn't hear the objection, so that
Leading.
Oh, okay. With respect to the Kenneth Copeland interview, did you take it at face value, everything that you heard in the interviews, or did you do anything to decide how you would treat the information?
Well, on listening to the interview and taking notes, I endeavored to corroborate as much of his statement as I could.
Okay. Did that involve listening to other interviews and jail calls as well?
Yes.
Would you tell the jury what other interviews you listened to without talking about what was said in the interviews themselves?
Sure. Well, there was the interview of Demiki and Garlington. There was an interview of Quindarius Zachary. And when I say there was an interview, I'm contemplating in my mind that there was only the one, but it is possible there were perhaps 2 or even 3 interviews, but I'm only recalling off the top. They may have all just run together as I listened to them. But as far as I know, there was at least one interview of everybody that I'm mentioning right now.
Okay. And with respect to Quindarius Zachary, did you take part in a 2017 proffer of Quindarius Zachary or include that as a part of your file?
I did, and it was recorded. I have it on a disc over here as well.
All right. And did you also listen to the August 2015 interview of Mr. Zachary?
I believe so. Yes, that would be the one.
Would you tell the jury what cell phone records or what cell phone numbers you found of interest after listening to the interviews?
Well, there would probably be a few, but I do, and I can't recall off the top of my head what specific cell phone numbers were mentioned during each interview. For example, depending on the interview, the party may have identified their own cell phone number or somebody else's cell phone number. But the numbers that were primarily of interest to me were those for which Detective Tyrone Dennis obtained phone records. And the numbers that he obtained, I believe, were primarily, if not exclusively, from either A, the interviews that he conducted, or B, from cell phones that he found during the course of his investigation. He was able to forensically analyze and extract the number therefrom.
Now, you mentioned last time you were on the stand getting the videos or the surveillance videos enhanced, the ones from the Texaco and the barbershop.
Yes.
Was there any other surveillance footage that you were able to obtain that was not a part of the original file that Mr. Detective Thorpe gave to you? Is the surveillance footage from the Texaco and the barbershop the surveillance footage that you used in making your decisions about what to look for next in this case?
From what I recall, I was primarily, if not exclusively, focused on the surveillance footage from the Texaco and the barbershop.
Okay. Who had you listened to the interviews from by the time that you did go into and look at the surveillance footage from the Texaco and from the barbershop? Or did you do that first?
Well, so I watched the surveillance footage many times.
There's
I'm sure I listened to while I was watching the interviews, I watched various parts of the footage. After I watched the interviews, I watched various parts of the footage. It wasn't as regimented as I had like a checklist where I watched the videos and then I watched the interviews, and I would keep revisiting things as I went through the case file.
Other than looking for someone in a particular place like a park bench in the surveillance footage, what was it that the surveillance footage was able to give to you that you found a value in this investigation?
Well,
I'm going to object to the form of the question. What he found of value is not relevant, and I would ask that.
I can rephrase.
Okay, thank you.
What from the surveillance footage were you able to utilize in furthering your investigation?
well, first of all, it marked the exact time of the homicide, which broadly is just very important because it allows me to establish a time.
Objection again to the testimony. What he found to be important is not relevant. I ask that be struck.
Your Honor, I ask permission to respond. With respect to what DDA Sprinkle did in gaining information about this homicide, as with any other witness, we'd ask that the court allow him to give the jury insight into how he gained the information that he got and made the decisions that he made.
Okay, let's just stick to the facts without value judgments. Go ahead.
Okay. After you were able to get phone records, listen to the interviews, were you personally or your investigator able to obtain social media records?
Yes.
How did you decide which social media records in this case you needed to look at?
Again, objection. How and why is not relevant. What he obtained is relevant.
Your Honor, how and why?
Overruled.
Thank you.
Well, I was focused on the social media of the parties that were of interest, either persons of interest, maybe witnesses, just as much. Whenever a name came up, I endeavored to find their social media, regardless of whether or not I actually thought that they were directly involved in the homicide. Perhaps there'd be something on their social media that would shed some light or illuminate something for me.
Now, did you ever look at the social media of a Quindarius Zachary?
I do, yes. I recall looking at his social media, yes.
Do you recall what his handle or handles were for various social media platforms?
Not off the top of my head, no.
With looking at your report, refresh your memory?
Yes.
Would you please look at your report?
Yes, and that's what's on the laptop in front of me, incidentally.
Okay.
Yeah, I just have it so I can do word searches.
All right.
I mean, I know he went by the moniker Little D.
Okay.
Yeah, I mean, unless you can point me to it, I don't know that I actually put a screenshot or an image from Mr. Zachary's any of his social media in my report.
Okay. I'm going to show you what has been marked as State's Exhibit 360 Yankee. Speaking of social media, 360 Yankee through 363 Yankee. At what point did you begin looking for social media photos related to Javaris Bradford?
That would have been, again, I don't know the specific date,
And I
but
don't mean the date. I mean, what was your attention turned to Javaris Bradford?
Mr. Bradford caught my interest because as I said, I already had phone records belonging to various parties. These were phone records I think were primarily, if not exclusively, obtained by investigator Tyrone Dennis. He caught my interest after I saw his number and his number being 404-957-8008. His number I found in the phone records of Quindarius Zachary, Demise McMullen, Kenneth Copeland, and Kelvin Treadwell, meaning that I called detail records for those four people. And as I looked through them, I found that in close temporal proximity to the homicide, or maybe not, when I say close temporal proximity, it could be like within a day or two of the homicide, not necessarily within like 10 minutes. But I saw that he was that number, and I didn't know whose number it was when I first saw it, was a common number between them. In addition to that, when I ran it through the Fulton County Jail inmate call database, I found that another person who was an associate of those four people called that number, and that'd be Martinez Arnold.
Okay.
Martinez Arnold, aka Duke, was an inmate at the Fulton County Jail. So I ran 404-957-8008, which 404-957-8008 through the Fulton County Jail's inmate call database, and I found two calls, I believe, that were placed from Martinez Arnold on the night of the homicide. And I think the first one was at 8:18 p.m., which was an hour after the murder.
Okay.
And so after I listened to those calls, I wanted to know a little bit more about Mr. Javaris Bradford. And as part of that process, I found his Instagram page.
I'm going to show you now that it's been marked as State's Exhibit 360 and provided to the defense. State's Exhibit 360 Yankee,
I'm sorry, can I see you?
absolutely. 361 Yankee and 362 Yankee. Here you go. Try to look at it.
I feel like I asked y'all to share exhibits that you were going to use with witnesses prior to using them with the witnesses. Is that not happening?
I believe that this has been shared for quite a while now.
It is, it is,
Okay.
we just want to make sure which ones you want to.
Additionally, I will show to you 363 Yankee and provide to anyone who would like to see photos. 363 Yankee. Do you recognize what has been labeled 360 Yankee? Thank you. 361 Yankee, 362 Yankee, and 363 Yankee.
I recognize these, yes.
How do you recognize them?
These were, I found Mr. Bradford's Instagram page. The moniker that he went by on said Instagram page was that is spelled IM_living, LIVING_great. When I found a picture or a post being a picture, sometimes with text accompanying it, although on these 4 pictures, it doesn't appear that Mr. Bradford actually posted any text along with the pictures. They're just pictures. I screenshotted them. And these were the screenshots that I actually took as I viewed Mr. Bradford's Instagram page, the content of which was visible to the public.
Okay. And are those fair and accurate representations of the pictures depicted on the pages that you were looking at, Mr. Bradford?
They are, yes, they're printouts of the digital images that I captured, yes.
The state tender states Exhibit 360, 361, 362, and 363 Yankee.
Those are admitted.
Thank you. Now, looking at 360 Yankee, would you tell the jury what they're looking at in 360 Yankee and what relevance it had to what you did after you got these social media posts?
360 Yankee depicts Javaris Bradford standing behind a Pontiac Bonneville, a gray in color Pontiac Bonneville. And I want to make sure, I think it's a 2002 Pontiac Bonneville. I want to get that right, so I'm refreshing my recollection. But I'm pretty sure it's a 2002 Pontiac Bonneville. But at any rate, it's a gray in color Pontiac Bonneville. And the reason why that caught my interest is because there was actually several photos I found that depicted him alongside Pontiac Bonneville, and that caught my interest because it let me know that that was probably the car that he could be found in.
Okay. Why were you interested in a gray Pontiac Bonneville at the time that you saw these images on Mr. Bradford's page?
Well, at the time I saw these images, I wasn't.
Okay.
I mean, not really.
What did you see or hear, without getting into what anyone said, that caused you to take interest in these photographs? If it was an interview, he does not have to say what that person said. It doesn't.
Well, I can say this. I looked at the surveillance footage, and I knew that there was some type of gray car or cars that were involved. So gray car in general would have caught my interest. And when I say surveillance footage, I'm referring to the surveillance footage from the cameras that were mounted on 330 McDaniel Street, that being the barbershop in the parking lot, which Donovan Thomas stood at the time that he was shot and killed. But then there was other surveillance footage from the Texaco station. And so and to be clear, just so we're clear as how the process went, when I first found these images, I was kind of generally interested. I said, oh, a gray vehicle, okay, a gray sedan. But then as I went back and I reviewed the surveillance footage from the Texaco station yet again, I became considerably more interested in these images because I saw a gray Pontiac Bonneville on that footage in close temporal proximity to the homicide. And because that Texaco station was in close spatial proximity to the barbershop, that particularly caught my interest.
When you said you went out and looked at the scene, were you able to determine and explain to the jury how far the Texaco that you were looking at, the images on the Texaco that you were looking at, were from the barbershop at 330 McDaniel Street?
It was about 100 yards.
Okay. And would that extend beyond the doors of this courtroom, out to the elevator, or something a little bit different?
It would be from about where I sit right now, probably about twice the distance from where I sit right now to the elevator. So from here to the elevator, double that.
All right. Now, when you were out there, was there a line of sight from where you were looking at on the Texaco footage to the front of 330 McDaniel Street?
Yes.
All right. Did you notice whether there were any street lamps or any kind of lighting out there as well?
There were. I don't recall if they were working.
Okay. Now, after you looked at this Texaco surveillance footage, did you only look at around the time of the murder? In other words, if the murder happened at 7:22 p.m., did you only look at 7:22 p.m. and a few minutes before and a few minutes after?
No, I looked. I believe the footage from the Texaco that was of interest to me actually started at 6:38 p.m.
Okay. Would you tell the jury why or what it was about 6:38 p.m. that had any significance?
Objection as to relevance.
Your Honor, I would ask that.
Overruled. Go ahead.
It was actually 6:41 p.m. having reviewed my notes, so it's about 3 minutes after that. Well, a 2002 Pontiac Bonneville looked identical to the one that appeared on Mr. Bradford's Instagram page, pulled up to a gas pump at that gas station.
All right. Do you remember which gas pump? In other words, was it the one furthest from 330 McDaniel in the middle or closest to 330 McDaniel?
It was an inside gas pump. It was in the like bank of gas pumps that would have been closest to 330 McDaniel, but the vehicle wasn't utilizing the pump that would put it in the absolute closest spatial proximity to 330 McDaniel, if that makes sense.
It does. Now, when you say the vehicle wasn't using the pump, did the vehicle use either pump at that gas station for the entire time that the vehicle sat at the pump?
No, I don't believe that anybody ever gassed up the car, if that's what you're asking. I don't believe anybody, from what I mean, obviously the whole thing's on video, but I do not remember anybody using the pump. I'm quite sure nobody actually fueled up the car while it was parked there at the pump.
At any time while you were looking at it, were you able to see individuals get out of or get into the Pontiac?
Your Honor, I would object as to relevance. Also, as the best evidence, the video has been introduced.
Sustained.
Thank you.
Did, Your Honor,
Mhm.
may I ask the witness whether or not once he looked at it and saw whatever he saw,
Well, you can go ahead and
thank you.
ask that and I'll see if it's.
Did you recognize any persons that got, and not from knowing them personally, but did you recognize any persons getting into or out of that Pontiac?
Objection as to relevance. The jury can make their own determination from the evidence that's already been admitted.
Sustained.
That you looked into further? Did you further look into anyone that you saw getting into or out of that Pontiac?
Well, yes.
Who, would you tell the jury about one person that you saw getting into and out of that Pontiac? that
I'm
you
going to
looked further
object. Same
into?
question.
What, ask the question again?
Would you tell the jury about one such person that you saw?
Sustained.
Did you see Diamante Kendrick getting out of the Pontiac?
I did.
Objection.
Sustained.
Move to strike, Your Honor.
It'll be stricken.
Who did you see getting out of the Pontiac?
I'm going to object. It's the same question.
Sustained.
Your Honor,
Yes.
would the court allow me to either approach and explain or allow the state to get information we believe will be made valuable to the jury at a later time? In other words, would the court please conditionally allow us?
Love is getting hammered. She must be up there begging.
Watched the Pontiac at the gas station.
And incidentally, on looking at my report, it's a 2001 Pontiac Bonneville, according to my notes.
Thank you. After you saw that 2001 Pontiac Bonneville at the gas pump, did you see, can you tell the jury who it was you believed that you saw getting into and out of the vehicle based on the information you had at the time?
Well, there were multiple occupants of the vehicle, but I believe you're referring to Diamante Kendrick.
Okay. And what did you do once you saw Diamante Kendrick? Did you just see him or look at or observe him getting out of the vehicle, or did you do something else with that information?
Well, I wanted to speak with the other people that were with him in that Pontiac Bonneville and another vehicle that appeared in the frame at some point.
Okay. Now, when you say the people that were with him, were you ever able to make a decision about who you believed the people were that were with him in the Bonneville?
I eventually determined who they were, and I spoke with them.
Okay. Did you only look at the inside or the outside, rather, of the Texaco station footage while you were reviewing this file to make decisions about the next step?
No, there was footage from the interior as well, the convenience store that was adjacent to the gas pumps.
Mhm.
I looked at that too.
And were you able to get closer up pictures of anyone inside that gas station?
Yes.
Now, did you find Kenneth Copeland in order to assist in your investigation? And I'll be specific. Did you ever obtain any for that?
Just answer what it is that you think that is going to be the other incidents.
Your Honor, the Dexter Montgomery incident, the Adele Drive incident, incidents that involve Mr. Copeland, and the information that he was able to obtain and how he used that information.
All right. And what are the objections?
All right. So the objection is relevance. The objection is that it explains his course of conduct, which is not necessary, not relevant. I think the predecessor court heard at length the information about Dexter Montgomery. Several witnesses were called, detectives, investigators, witnesses from a prison system. And so the jury has heard that evidence before. They have heard the evidence about the Adele Drive shooting, both from officers who have come before the court and testified about it, as well as individuals who were there at the location. They have heard from Mr. Copeland for a long time, and both videos of him, detectives testifying about him previously, officers testifying about him previously. All of this information has been put in front of this jury previously. There's no relevance to Mr. Sprinkle at this point saying, again, regurgitating all of those and saying why they were important to him or important to the investigation. What importance they have, ultimately, they can argue in closing, but the jury's this is already before the jury. And so if I did not say that
the court not allowed the inquiry into why any other witness, officer, investigator did what they did as well. We believe that it allows the jury to assess what happened during this case, assess the motives, the reasons why steps were taken, and to rebut the inference that the defendants are attempting to cause the jury to draw that somehow or another anyone in this particular case was targeted.
All right, I'm overruling the relevance objection and the cumulative objection, so he can say, I also looked at XYZ file and then move on from there. And Mr. Sharp, what was your?
I was a little slow on the trigger, but I was also hoping to object to hearsay, and this is my concern. Miss, something we just do. You can use upside places like shall.
Thank you. Go ahead, Ms. Love.
Thank you, Your Honor.
Whoops.
Mr. Sprinkle, we talked earlier about the numbers that you obtained records for and that you reviewed records for during the course of your investigation. Can you tell the jury whether you were able to find the number 404-621-4090, photograph, date, and caption that you observed?
Yes.
The state tender states Exhibit 510 Yankee as evidence.
Admitted. Yes.
Marked as states Exhibit 510 Yankee. And I'll leave a copy for whomever wants to review it here on the stand. And ask you if you recognize, do you recognize the picture and the date?
I do.
Okay. Did you obtain that particular picture and posting during the course of your investigation into the murder of Donovan Thomas?
Yes.
Okay. Is that a fair and accurate depiction of the photograph, date, and caption that you observed?
Yes.
The state tender states Exhibit 510 Yankee as evidence.
Admitted. Yes.
Permission to publish, Your Honor.
That's it.
Looking at State's Exhibit 510 Yankee on the screen, whose social media account did you observe this photograph, caption, and date to be on?
Shannon Jackson, who also is known as Shannon Stillwell.
All right. And what is the handle or social media handle of this account?
OG_. Bool, spelled BOOL.
And are you able to tell the jury, if we can zoom in a little bit so that it can be seen a little bit, the date and time of this posting?
January 10th, 2015 at 9:58 p.m.
And what is the caption?
Overlooking the city with a lot on my mind, followed by a series of, and when I say series, I mean 4 emojis that depict faces.
Okay. Now, at the time that you saw this, did you know where it was that this picture was taken from?
It's like the inside of the Sky House
I mean,
condominium.
based upon here, so Your Honor, I would object.
Sustained.
Your Honor, statement of,
Posted in this Instagram comment.
That it says this phone number is from Justin Cobb's Instagram or social media posting. This is who it belongs to. So that was my objection. I believe the objection was well founded. I believe the state purposely put
That none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so
posted in this Instagram comment. And
Posted by the owner or user of the account?
That was
Yeah.
false speculation, not object.
If he has a basis to testify.
Are you able to see and tell, looking at the posting itself, what name the number is next to?
I
What
would
handle
renew
the
my
number
objection,
is
also
next to?
object on the basis of hearsay if he's reading from a document.
It's already in evidence, Your Honor. And,
Okay, when
Your Honor,
we were up here at the bench,
so, Your Honor, I'll ask additional.
posted in this Instagram comment. And
Posted by the owner or user of the account?
That was
Yeah.
false speculation, not object.
if he has a basis to testify.
Are you able to see and tell, looking at the posting itself, what name the number is next to?
I
What
would
handle
renew
the
my
number
objection,
is
also
next to?
object on the basis of hearsay if he's reading from a document.
It's already in evidence, Your Honor. And,
Okay, when
Your Honor,
we were up here at the bench,
so, Your Honor, I'll ask additional questions that I think will,
Sustained.
okay. So, after seeing this
Your Honor,
number,
I have a motion, please. May we step up?
yeah.
I'm going to excuse y'all to the jury room.
Your Honor, may we excuse the witness?
Yeah, Mr. Smirker, you can go ahead and step outside for us. Thank you.
Your Honor, so
Your Honor.
well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting. This is who it belongs to. So that was my objection. I believe the objection was well founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
May I respond?
You may.
Judge,
Can somebody put the document up? I don't want to.
yes. Would you put it up? First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments where's the phone number? There it is.
Yeah,
Okay.
the comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, No.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor,
to testify to that?
I'm asking him, and I understand the court, I'm asking him
you?
what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked, though. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is it?
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The
Is
entire
phone number one of the comments?
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally
And
asked
I
it.
asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there and I asked for everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse
I asked,
here. It is what it is. I think that the state was disingenuous about it. State's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm
I
asking
mean, I
for one.
can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back. All right, I'm going to deny the motion for mistrial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to, I'm going to exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement. So let's get Mr. Sprinkle back. Did you want to put anything on the record, or are you just getting ready for the jury?
I'd like to put just a matter
Go
before
ahead.
the record for the court.
All right.
Your Honor, this is from United States versus Roberts, Roberts. It's 640F second 255. It's the Ninth Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway, based on that? Yes, potentially we get to that point at some point. But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
Well, I don't know what they think, but I will say this. This is not becoming in the state of Georgia of a trial. And it is all the time, Your Honor. It is all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume the other people on trial will agree. It is this constant hiding balls, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing with the court. And I think that it does rise to a level now, but I understand the rule. But I think that we're well beyond it. And the reason I said from all these things is it's literally.
Oh, I saw that. I know. I mean, I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team. Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, and we're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
Your Honor, would you allow me to either renew my motion for mistrial or consider that my motion is renewed before the asking of the next question, please?
Yes, it's renewed.
Thank you.
The Harvey rule does apply.
Yes.
All right, Missouri.
Thank you. Ladies and gentlemen, upon further discussion, that last exhibit, which is State's Exhibit 528Y, is excluded from evidence. And so that means that y'all need to disregard it entirely in your thoughts and in your deliberation in this case. And as well, you need to disregard any testimony that might have been given about that particular exhibit. All right, go ahead, Ms. Love.
Thank you, Judge. DDA Sprinkle, you were asked on cross-examination